case. Before I introduce him, I just want to say for myself, I am not an attorney. I am not a lawyer. I've never studied law. I'm not a litigator. I've never studied any type of litigation, whether it be blockchain or anything like that, in college and high school, or any type of schooling. So I just wanted to get that out of the way. That's just my disclaimer. Nuclear Herbs, I am happy to announce you. Thank you so much. How are you today, Nuclear?
Hey, I'm doing great, Corey. Thank you for having me on. I appreciate it. Yeah, I'm kind of, this is my first stream with anybody. So, be gentle, I guess.
Absolutely. I promise the Olive Garden breadsticks, man.
Thank you, man. I appreciate that. That's the only reason I go there. I just want to make a standard disclaimer as well, if you don't mind.
Go ahead.
Yeah, first of all, nothing I say is legal advice. Nothing I post is legal advice. I actually have zero knowledge of anything that's actually happening with the SEC or Richard Art's lawyers. I've never had any contact with Richard or spoken to anyone on his behalf. I'm primarily a litigator, but I've never litigated any crypto cases or blockchain cases. But I'm calling things as I see them to try to present them in a way that people can easily understand based on 20 years of running cases in courts. So I've done lots of different types of civil cases over those years, and they more or less follow the same track because the rules are set up the same way. So while each case lives on its own facts, and it's just a matter of understanding the process. And when I started doing this, as I mentioned to you before, like when I started doing this, it was because there was so much just absolute nonsense going on out there with people just making wild predictions and wild speculation and not really understanding what was going to happen or how things actually happen. And I just figured I'd step in and try to calm the situation down a little bit the best I could by explaining the process a little bit. So hopefully it's helping.
No, and I'm grateful for that, because your information has been extremely valuable to the X and PulseChain community. I can see through the likes, the tweets, and engagement. Because let's be honest, people like me, streamers like me, influencers on Twitter, we don't have any experience in litigation. We don't have any experience in blockchain legislation. We don't have any experience in legislation to begin with. I'll speak for myself. I don't have any experience. I don't know about many people who are doing it, but I can infer that many people don't. And it's just, influencer breaking news, stuff like that you see on Twitter. But it seems like you have been the only person who has a grasp on what is going on. So I appreciate you highlighting, who you are. And I just want to, start with a formal question. Like you brought up a little bit of it briefly. I'd like to ask you your background, like as a former attorney, and your expertise surrounding litigation. Like, can you tell us about like your experience in the attorney world?
Yeah, sure. I've been practicing since 2001. Almost all of that time I've been in, a solo or small firm guy. I think the largest firm I was ever in was my first one. It was 12 attorneys. That was, seemed huge to me. I've kind of enjoyed the whole solo small firm thing, where a lot of times it's just been me and a partner, and which is good because you get to kind of pick your own cases. You're not handed something by a partner, told to do this, that, and the other thing. You get to evaluate the client and say, this is the case that I'd like to run, or this is the case that I don't want to deal with, where you don't necessarily get to make that call if you're in a big firm. So I've run some interesting cases over the years. Everything from a lot of business and contract type disputes, done a decent amount of probate type litigation where, families are fighting over mom and dad's stuff after they're gone.
Yep.
That's more interesting to me. Not a lot of attorneys do that. It's kind of, it's got its own little set of rules and procedures, and not a lot of attorneys understand them. So, I've been up against a number of guys who do strictly civil cases, litigate strictly civil cases. And, it's just interesting to watch them kind of fumble the ball sometimes when it comes to, probate type procedure.
Right.
Just two different, it's like learning, it's the difference between Spanish and Portuguese. it overlaps a lot. You understand a lot of it, but it's not really the same thing. So, yeah, so I basically, kind of had enough a couple of years ago, started winding down, and, I've got a couple things left to close out, so I'm not entirely done. But, from now on, I'm pretty much just going to work for one small company on an as needed basis. And that's, just to do stuff here and there, but that's it. So moving on, doing other stuff.
No, and I appreciate you highlighting that, because I think it's very important to people to understand your background, your expertise surrounding what has gone on in the litigation world over the last couple of decades. So I appreciate you highlighting that. So now I want to get into what has been going on, who the individual characters are involved in this. So Nuclear, many people have been highlighting the reputations of the lawyers and the firms Richard has hired. Can you please illustrate to us who they are and why they're so significant in this case?
Yeah, well, let's start out with the fact that, crypto litigation is, by definition, hasn't been around that long. And,
of course.
There's not a lot of people that do securities type litigation to begin with. It's kind of it's not considered a specialty, but it is kind of a specialty. So there's very few people that are going to be good at it. I spent a little time yesterday kind of looking up some of these guys. I was going through some of the some of the cases that some of the reported decisions that their name was on. There's some interesting stuff out there. I've had people ask me, for one thing, first of all, I'll just say that this appears to be a substantial team. This is a good team. Like, if I had the kind of money and I was in Richard's position, this is probably the team that I would go after. You got to think that, let's be real here. Like, Richard kind of knew this was probably going to be the case at some point, given the SEC's position on crypto over the last couple of years. So there's no way that this guy Richard didn't have somebody on speed dial, for 2 years, and then when the SEC finally filed the complaint, it was okay, let's get a team together, and they started working on it then. To think that he's been hiding out this whole time is just, it's silly. But there's guys who have inside knowledge. Like, he's got a couple of former SEC guys on there. He's got a couple of, he's got some other litigators, specialists in litigation. Specialist is a weird word in law. So, because a lot of times you have to be certified to be called a specialist. So what you and I consider, like, as a civilian, a specialist, is not what the law considers a specialist. So you can't really, it doesn't really mean the same thing. It's the same word, but has two different meanings. But one of the other things I've had people ask me is, what is this, what's this going to cost Richard in attorney's fees?
Yeah.
And so I actually, I found one of his attorneys. What was his name? I think it was, I got it written down here. Let me see if I can find it real quick.
Yeah, take your time, guys. Take your time, man.
Yeah, Nicholas Inns is one of his attorneys. He's got a case that was, I can't remember the case now. I had it up on my screen a while ago. But they were arguing attorney's fees in a case. And so they had presented to the court, like they wanted an award of, I don't know, $250,000 in attorney's fees, some nonsense. Judges are required to take a look and evaluate attorney's fees awards and not just rubber stamp those, and make sure the amount requested matches, with the amount of work put in, that kind of thing. So a lot of times attorney's fees, requests get reduced along the lines. I mean, it's not really uncommon to see it happen. But what was amazing to me is I was looking at this, and the requests were put in for that firm. I can't remember which one it is. I think it's Gray Reed. Could be wrong, but I think it's Gray Reed. It was $1,690 an hour for the partners, $1,385 for the associates, and $550 for paralegals. I'm like, holy shit, man. Just think about how much Richard's racking up on this, per hour with 11 guys like this. Like, damn.
I can imagine.
So, I mean, that's going to add up pretty quickly, but yeah. Wow. I'm still stunned at that. I mean, when you consider like probably the average rate in Arizona is between like, three, somewhere between $300-400 an hour. Damn.
Yeah, that's wild to me. That amount of money. I mean, the amount of money that I can infer going into his lawyer fees are astronomical, to say the least.
It's nuts. Yeah. One of his guys, I think it is Michael Liftick. If I got the name right, I can't read my own handwriting most of the time, but
it's okay.
He was on the team that defended Bittrex too. That case ended, I think, last year, but with a consent judgment. So I mean, sometimes that's your best way out of something is just to agree and pay your fine and get the hell out. So you do what's best for the client, and if that was the best thing for the client, then that's what it is. But I talk about the attorney's fees to make a point, and largely that point is the SEC is going after how many crypto projects, and if you can't basically pay upwards of $1 million in attorney's fees, just write a check for it, you're probably not going to be able to defend your case very well. You might just need, you probably just need to, let the SEC take their scalp, pay a fine, and go away because you can't afford to defend it. It's not really the way the system should work, but it's kind of what's happening. So, I mean, the government doesn't have a budget when they sue you. They'll just bring as many people and spend as much money as they feel like it. You on the other hand, even if you win, you're not getting your attorney's fees back. So it's
absolutely
not a great situation to be on the other side of those, what we call the other side of the V. You don't want to be on the other side of the V, SEC V, somebody. So anyway.
No, I'm sorry. Yeah, no, that makes perfect sense. That makes perfect sense.
Yeah.
And
some of his other team, they have, some pretty high-end litigation. Kristen Toller has done some high-end litigation with like Iraq Telecom, if you want to, get bored and want to look up cases like that. One of the guys, Chris, I can't read my own handwriting again. Something. Chris Davis, maybe? I don't know. I can't. Like I said, he's got a lot of extensive SEC experience. He's also I think he spent 9 years at the SEC. He's an attorney and a CPA. This is a pretty solid team when you get right down to it. So I am pretty confident that they're going to do as good a job as you'd see from any set of attorneys in this country.
No, and I appreciate that because I know that there's obviously been a lot of uncertainty about who Richard's team was or is, their expertise, the proposition of their influence and their ability to litigate this case. So highlighting this is very, very important. Thank you, Funding Jim. So I agree with you 100,000%. And I want to ask you this. So here's something that I've seen is we saw recently the SEC respond to Richard Hart's lawyer's letter describing motions to dismiss that they intend to file. What does this response entail and mean?
All right, let's clear up one thing because I've seen it a number of times out there.
Please.
No motions to dismiss have been filed yet. So there's been a lot of people who have thought that the letter constituted a motion to dismiss. It does not. Richard, what happened was, behind the scenes, there have been a number of discussions between the SEC and Richard Hart's attorneys. And that's evident from, I don't know that personally, but I mean, it's pretty obvious from the letter that was filed by Richard Hart's attorneys saying that there have been discussions behind the scenes. So I'm going to go with, they didn't lie about that. They know what they're talking about.
Of course.
And that makes perfect sense. I mean, this is something that happens in a lot of cases. If somebody came into my office and they had a complaint filed against them, and I looked at it and I'm like, man, there's this, that, and the other type problem with it. Sometimes we'll get on the phone and, with opposing counsel and just say, what are we doing here? Is there, what is it you want? I saw what you wrote, but what do you want? And we can start discussions along those lines. And, if there's some way we can move forward without, paying filing fees and, spinning up the whole litigation process, sometimes that's the best result for the client. I mean, if the client doesn't have a, pretty hefty retainer to put down in litigation, they're probably not going to have the money to continue, So, I mean, what are you going to do? Get them a couple of months into the case and now they're broke and now you can't continue either because they can't pay you. It's not a good situation for anybody. So a lot of times, I'll have this kind of conversation where I just call up the guy and just say, this is, what are we doing? Let's do this. And so as a result of that, they agreed that Richard would be filing motions to dismiss under Rule 12. And the SEC and Richard's attorneys agreed on a timetable for those briefs. Now, the timetable for the briefs is very long compared to most briefing schedules. When you file a motion, you typically see it starts a clock, and you've got 10 business days to file a response and 5 business days to file a reply, that kind of stuff. It's all in the court rules. If you get bored, I think it's Rule 7 something. I don't remember exactly, but all of those rules are there. Like when you talk about filing something on April 8th and having not to respond for a month, and then another however many weeks left for the reply brief, that is a substantially long briefing schedule. So I think it's why when the court put out in the scheduling order, like, this is an extremely generous schedule. We're not going to be extending any dates. That's what it meant. I saw people speculating as to, what that actually meant. He's basically saying, don't come back at me and ask me for more time because you're not getting it, because this is already more time than you should have. So on or before April 8th, and I'm going to say on because there's no reason, now that the schedule is out, there's no reason to give the SEC extra time to respond. So I'm going to say April 8th you're going to see at least 1, maybe 2 or more motions to dismiss filed by Richard's attorney. They telegraphed what's going to be in them. I personally really like the 12b2 arguments, which is Richard doesn't have minimum contacts with, New York, the United States for that matter, to grab him out of Finland, force him to appear in a New York district court. And, there's a lot of merit to that argument. Minimum contacts has been around. I think I posted something on International Shoe a couple of weeks ago or whatever, talking about how personal jurisdiction, the requirements for personal jurisdiction require a court to analyze whether somebody has contacts with that, venue, that jurisdiction, in order to make it fair for them to have to show up. In this case, I think they raised some good arguments, and I think they wrote that letter. It's my own personal opinion. I have no idea really, but sometimes you write things just to see if somebody's going to respond to them, and the SEC basically came back and, didn't really bolster their argument on minimum contacts. They just kind of made it say, they said something along the lines of, Richard advertised on YouTube or, put out streams on YouTube. And, that is, and it is viewed by citizens of the United States or whatever. That is not going to cut it. There's case law on that. I mean, just because you have a website out there doesn't mean that you can grab somebody who, and drag them into the United States to answer a case because they were exposed to the internet. It's not going to work that way. There's a case, I want to call it, I think it's Zippo. It was like a late 90s case that talked about kind of a sliding scale for personal jurisdiction, where if you just basically throw up a website and it's just informational, and you can't really interact with it, you're not taking payments, you're not, interacting with people over it or whatever, it's not going to be considered, anywhere near enough to, go out and, grab you from overseas and bring you into a American courtroom. On the other hand, like if you're doing business over a website and you're, taking payments and supplying products and whatever, that's pretty clear that you're going to be subject to personal jurisdiction and, wherever you're selling those products. So there's a lot of, laws decide in the middle ground, right? So there's, I guess we have to do, so at some point it's going to be analyzed what Richard's websites did. I don't think that they were interactive in any way. I mean, they pointed you to things, but they didn't take your user information. They didn't process payments. There was nothing that actually happened. So I think it's a much harder sell for the SEC on something like this. There's no, let's see, there was another point. The SEC also in their letter pointed out, and the reason they pointed out a case that had no bearing on really anything is a minimum contacts case, but it was decided by the same judge. It was decided by Judge Amon, who's the same judge in Richard's case. That's going to be deciding his minimum contacts with the jurisdiction, whether or not the case can move forward. So if you don't mind, do you mind if I talk about that for a second?
I'm quiet because please, you're the expert, not me. Please.
I'm not an expert in anything, but I just kind of know how to read stuff. So just a different language. That's all.
Of course.
Anyway, it's called the Plex Core, and it was a coin that came out in like 2017, 2018 or something like that. I posted thank you, Matty Allen. He helped me. He created a link for me, and I posted that the other day. Appreciate that.
He's in here.
Huh? Is he?
He's in here right now.
Right.
He's a good guy. I love him. He's a great dude.
Yeah, I'm looking forward to meeting him someday. Good dude. Anyway, so the Plex Core case, essentially they pre-sold a bunch of coins. They promised a return of 1,354% within the first 29 days of its launch. That was a promise that was made. They were selling merchandise for it on Facebook. They had Facebook targeted ads inside, North America. And interestingly enough, that case followed a slightly different tack than the SEC is pursuing with Richard. Even though it was the same type of claim, unregistered securities claim, what they did in that case was that they initially filed a TRO, a temporary restraining order, and basically froze the assets of the company. So they collecting like $15 million from various payment processors and whatever, in order to sell the coins. And the SEC froze that money because they were largely American payment processors, and banks. So they just got the TRO and stopped any movement of that. They also requested discovery, a limited amount of discovery prior to the motion to dismiss hearing. They haven't done that in this case. And if they were going to, they would have by now. So in that discovery, they got a couple of declarations from people. Declarations like an affidavit, but it's not notarized. It's just signed under penalty of perjury. So it's kind of used the same way. But they had declarations from people who talked about how they came to learn about the Plex Core coin and how they sent money in and whatever else like that. We're not going to have anything like that supporting the SEC's response here because they're just not doing it. They haven't filed a declaration. They haven't filed anything with the complaint. They've just basically said at least one. I think it said at least one holder of Pulse and PulseX lives in the Eastern District of New York. Great, thanks. Interestingly enough, and the SEC wrote it, right? I mean, so they're stuck with whatever they wrote, but they didn't even bother to put down whether or not that person bought it in secondary sales, which is the big issue in Coinbase, or whether or not they were issued it upon launch. So, I mean, if they bought it in secondary sales, we have an entirely different conversation than whether or not it was distributed on launch. So for an initial securities offering, the initial securities offering is kind of the big deal in an initial securities offering case, right? I mean, if you don't buy it that way, if you buy it on the secondary market, it's not an initial offering. So I found that to be interesting too. The end result was the court, Judge Amon, found it very significant that the promoter, the founder of PlexScore, had visited, I think he went to Boston during the time, set up accounts, did a bunch of stuff inside the United States, that, so they found minimum contacts with him. So that was one of the, I guess what I'm trying to say is none of the factors, none of the payment processors, because nobody put money into PayPal and it went to, pick up, it went towards your Pulse sacrifice or anything. None of that happened. So, it never went through any U.S. payment providers. No U.S. dollars were submitted at all with respect to any of the sacrifices, or even, whenever you initially purchased Hex, you didn't buy it through, by shoving cash through your computer. So there was no US dollars spent on that. It was all, it was all non-US dollar related. So, this is going to be a much harder case, I think, for the SEC to establish, personal jurisdiction, because, Richard hasn't been here. He hasn't specifically, they don't allege, and this is really what the point of a motion to dismiss is. It's saying you didn't say this happened. So it's the SEC's job in a complaint to say, this is what happened. This is why we can prove this case. So when you attack a motion to dismiss, it's, you didn't say this happened. Like it might happen, but if you didn't say it, then the court can't consider it at that point, So the best they can do is the judge can give them a chance to go rewrite it and see if they can comply with the pleading requirements and make your case, at least on the surface, potentially winnable. So I think this is going to be a lot more interesting. I don't know that it was the best idea for the SEC to bring up that case, because all it does is highlight the differences between what she found significant in the PlexScore case and what's going to be presented in this case. So I'm not really sure it helped them, but then again, I guess, like I told somebody else like a week or so ago, if it's the only pig you got to enter it in the county fair, then you just make it look as good as possible, right? So that's all you can do sometimes. Like, you just pretend it's better than it is. So.
No, that's a good analogy. And I know you brought up so one of the questions we had here was about, Judge Amon's, Richard Hart's judge, the other crypto case. Is this the other crypto case that you were referring to?
That is, yeah.
It is. Okay.
Wait a minute. Well, let's clear that up. It's the other crypto case that she has decided. It's not the other. Okay.
Yeah. I'm sorry. What did I say?
No, I didn't know if you were talking about one of Richard's attorneys arguing it, or whether or not it was the judge that.
Thank you for clarifying that. Thank you very much.
Sure.
So I want to discuss these dates because you brought up one of these dates specifically before. So there's, I'm presuming, significance to these following dates, and maybe you could shed light on them for people who
Sure.
May have seen stuff on Twitter or may just not know in general. So April 8th, July 8th, August 22nd, and October 24th of this year, based on a recent update. What significance do these dates have?
Okay, these are deadlines. April 8th, if Richard doesn't file his motion to dismiss by April 8th, he's not getting to. On or before July 8th or whatever it is, the second date, the July date, that's going to be the SEC filing their response brief. It's going to, they're just going to try, they're going to take a look at whatever Richard put in his motion. They're going to do their best to refute it and say, no, we believe that, he's established, minimum contacts. We believe that our complaint specifies enough that, we're allowed to move forward. Those type of things. I'll know a lot more when I see the actual arguments that are brought up, and I'll be happy to talk about it then.
Awesome.
See what's going on. I can explain kind of the, what the meat of the argument is. Sometimes you read it, but it doesn't really make sense because you have to kind of read around it, read through it, see what they're actually getting at. And then in August, Richard gets to file a reply brief. So it goes Richard, SEC, Richard. The reply brief, is limited to, the things that are essentially in the SEC's response brief. You can't bring up new things. You can't put something, you can't file a motion and then have the other side reply to it or respond to it. And then, you bring up all new stuff in the reply brief. That doesn't get to happen. So, because they don't get another chance at it to rebut anything that's in that reply brief. So you basically, it's the shortest of all the briefs, and you just kind of, get to put your last word in, if you will. And then on October 24th is going to be a hearing. Probably, my guess is it's not going to be as long as the Coinbase hearing, because holy shit, was that thing long. But it'll be the same kind of idea. They'll, the court will allow the SEC to argue their side. Richard's attorneys will get to argue their side. And my guess is she's not going to rule from the bench. I mean, that would be really rare to see that. So my guess is that, within typically 30 to 60 days, I would go on the longer end here. You'll see some kind of ruling out of her. And then, based on whatever happens, she would have the option of dismissing the case entirely, dismissing it partially, dismissing or basically putting it on hold until the SEC rewrites some stuff and see if they can pass the test next time around. There's a lot of options there. Or she could just deny everything and then move forward. And then what happens is it just goes to discovery. At that point, Richard would have to file his answer. So who's asking me like if I'm young? I appreciate that. Crypto King. I love it. Yeah, I'm 53, bro.
There you go. Yeah, I didn't want to make any claims or anything. So no. But no, and I
just sound good for my age.
So no, and I appreciate that, and it seems like there's a lot of value, like the immense amount of value that you bring, because there's I'm looking at the chat and there's 203 people in here. Jesus. And yeah, that's a lot of people. And guys, I would implore all of you to follow Nuclear Herbs on Twitter. I have his link in the description of the video, so please make sure to follow him. He has been on top of this so much recently, literally giving us navigating so that this community can actually understand what's going on and not have, people who have no experience in litigation or expertise surrounding, laws or stuff like that, being the ones at the helm telling people what is and what isn't, because those people shouldn't. The people who understand should. So now, Nuclear, I don't have any more questions. Is there anything that I may have missed before we start the AMA, if that's okay with you? Is there anything that I missed?
Yeah, I don't think so. I mean, you're welcome to do. It's your show. You do what you want to do. I'll just hang out here.
I want to make sure you're comfortable, dude. I mean, I know this is not a, it's definitely something that's very, it's a subject that, accuracy plays a vital role in it's sure. So is there anything that I may have missed?
No, but let me just answer like a question. I think I see Ted Nelson going by, and is Nuclear Herbs executed? I'll tell you what, I got into crypto really late. I was telling Corey about this earlier. I got in 21, early part of 21, and I didn't know shit about crypto for a long time. It just wasn't on my radar. So, until I started looking around, and, what really got me interested in crypto was the whole concept of smart contracts. And once I realized, that's tech that's going to change the world. Being a lawyer, I like, done enough contract work, understanding contracts. Smart contracts seemed interesting enough to me. So I started exploring that kind of thing. And that led me to watch, a number of, number of videos on the subject, number of things. And, one of the things I found, kind of early on there was Richard. And, a lot of people on this, in this space at the time, were spouting a lot of bullshit. I guess it's the same way right now. But Richard kind of made sense. He hit home on a lot of points. So I kind of tailored my worldview towards, what he was saying, because, everybody else there is trying to get you wrecked, and he's like, stop, don't trade, don't do this. I'm like, oh, what, who's somebody that's going to tell you not to trade their product? Like, it's crypto, right? That's the whole point. But and then I kind of understood what he was saying a little bit more and more, so luckily I was early enough, before the Pulse sacrifice was announced. But I'm solidly a believer in Richard Hart and the Richard Hart ecosystem. So I'll just say that.
There you go. No, thank you very much. Guys, so we're going to do the AMA now. Please keep the questions professional. RSB, I see that's a very good question. I'm going to ask that in just a second. There's 200 people in here, guys. Make sure to like and share this video for people who may have questions that have wanted to ask and maybe not be aware that this is going on. So please ask the questions. I will go down them as I see them. And so RSB has a very good question. In your opinion, Nuclear, does RH tweeting about PulseChain and Hex harm or benefit his case? Would Nuclear Herbs advocate silence until the case is over?
Are you talking about, let me ask you this, like prior to the case being filed or after the case being filed?
That's a good question. RSB did not clarify on that.
Let me just get into both of those. I mean, like,
sure.
What's done is done. Me, typically, when I have some, a client come into my office and they're like, this, that, and everything, I just tell them to shut the hell up. Like, for the most part, don't talk about the case to anybody. Don't, there's been horror stories everywhere, like of, a client forwarding their attorney's emails to their best friend and asking them if they agree with their term. Like, holy shit, that's no longer privilege. What are you doing? Luckily, it hasn't happened to me that I know of, but what Richard has put out post filing by the SEC, I don't really see that he's doing any damage to anything.
Okay.
So he's really not getting into the meat of the case. He's not discussing things that appear to be really controversial in the case. He's basically talked about rights, which I think he has every right to do. And he should. I mean, he's got a big platform, and if he wants to, talk about people's constitutional rights, go for it. I mean, I think that's.
Yes, I agree.
You're not going to shut somebody up. It's freedom of speech. He's 100% right on this, and that's exactly if that's what he feels is necessary to do, go do it. His attorneys will guide him along those lines. I mean, I assume that if he's, if he said, hey, can I put this out? And they said, no, he's probably going to listen to him. I mean, it's what you're paying the advice for, right? I mean, if you're spending that much freaking money and ignoring your attorneys, that's not really that smart. I think Richard's a lot smarter than most people, outside the community give him credit for. So, I think he's been relatively safe since this came out. So.
Cool. I'm glad to hear that. So Hexter has a question here. Based on what your perspectives are, he says, Corey, what's his opinion on RH winning this case?
Oh shit, I don't know. Too many variables.
Too many variables? Okay.
Yeah, too many variables. I don't even know what winning is. What do you define as winning? Like beating the SEC, getting it down to a $500 fine. What's winning? I don't know what that means. So it's really going to depend on the situation. Like, when a case starts, you have what I call a letter to Santa, which is a complaint. Like, I want this, and I want this, and I want this, and I want this, and I've been good all year, so you should give it to me. As cases move forward, a lot of those claims they don't look so good anymore, right? I mean, because you're able to, once the defendant gets involved and says, yeah, that didn't happen, or you can't prove that, or, I have evidence that refutes all that, the case takes on a completely different look. And, you know, a lot of times it's, you know, it's nowhere near as bad as it looked in the beginning with the initial filings. In fact, I'd say like 99% of the time, it doesn't look as bad, you know, as it did in the initial filings. And then people just go, oh yeah, okay, that makes sense. You know, I see where he's going with that. I can see why that's not a great argument, or, you know, or whatever. So I can't handicap it right now. I think I posted this before. I think that you know, whether they deserve it or not, the SEC is a minus 100 favorite in any securities case as to whether or not the thing is a security, because I think they just get to say it at this point, and the court kind of defers to them. This is why, you know, if you don't know what the Loper Bright case is that was just argued in front of the Supreme Court, just, you know, Google that and read kind of the issue in that. It has to do with whether or not, you know, agencies can do things outside of their congressional mandates. This has to do with, and it's going to, my opinion, I don't want to handicap that case either, but I'm thinking that, you know, Loper Bright, I think that they're going to win, and Chevron. There's a case in 1984 called Chevron.
Okay.
And out of Chevron was the judicial philosophy, if you will, of deferring to agencies. Like if there was a question as to whether or not the agency had authority to do something, and they came in and said, yeah, we think, you know, this extends to our, you know, so we're going to do it. It's essentially what the SEC is doing right now, is they're saying, yeah, well, you know, we know that digital assets weren't around in the 1930s and 1940s when the SEC Act was implemented, and when the you know, when Howey was decided. But, you know, we think that, you know, Congress would have given us the power to do this, therefore we're going to take the power to do this. So I think the outcome of Loper Bright, if the court eviscerates Chevron, which my personal opinion, I think it should, agencies are no longer going to get straight up deference. So when the agencies are going to basically have to show that they have the authority to do something rather than just claiming the authority to do something. I guess that's the simplest, you know, way I can, you know, summarize that, I guess. So
no, and I appreciate that. And we have some more questions here that are actually really good questions, guys.
Sure.
We're gonna steer away from the financial questions like price prediction, stuff like that, based on the cases.
I'm not doing any of that.
Yeah, we're not doing any of that. It's just too difficult, and we're not doing financial advice here. We're just trying to make this an informative stream. So please veer away from those type of questions. Nobody can know those answers. So BK Handan has a very good question. Question for NH: what is the worst case scenario for Richard and or the RH crypto ecosystem?
Again, you're requiring like a whole bunch of variables to come true. You know, the worst case scenario, I guess, is whatever the SEC asked for in the complaint. So,
okay,
you know, that would be because they're not going to get more than that. You know, that's what they asked for. That's the relief they sought. So I guess that would be the absolute worst case scenario. You know, I don't think that I've ever seen the worst case scenario come into play ever, like in any case, because, you know, the cases take on new life all the time. Like, you know, as soon as the defendant shows up and says, you know, this is what we're arguing about, this is what, you know, then, you know, expectations change over time. So
of course,
you know, is it possible that like they're going to, let's put it this way, if they were going to freeze all of his assets or the SAC money, they would have done it with a TRO. They didn't. Why? I don't know. Because they didn't think they could get it. Probably. So that's not going to happen. It's not going to happen at this point. I don't see any methodology for it to happen at this point. I guess there's always the, you know, 0.01% chance that something could happen, but so I don't want to speak in absolutes, but I mean, when I say something's not going to happen, what I mean is there's a overwhelming probability that it's not going to happen, in the high 90s% that it's that it is or is not going to happen. So, that's kind of as absolute as I want to get. Are they going to take anybody's coins? How? They're in your wallet. Like, I mean, what are they going to do? Grab everybody's seed phrase? What are you doing? Like, I mean, let's be realistic here. They can't come after that. So, I guess there's a lot of things that, the SEC is the big 800-pound gorilla in the room, but they're still limited on what's realistic, and it's not realistic to think that they can freeze all of these coins or freeze all of his assets at this point. So, I guess, does that help? I guess so.
No, I appreciate that, and we have a really good follow-up question to segue.
Sure.
Do you think that, again, I can't sit here and say with absolutes again, and I don't think you can either, that Richard is in control of the SAC funds. We don't know who's in control of the SAC funds, but Chris Baker said, do you think that he was advised that it's okay to allegedly deploy SAC funds?
Not going to answer that.
Okay.
Even if he was, I'm not answering that. Like,
okay,
you know what I mean? I can't imagine what that advice would look like. So, I mean, that's just so far in the world of speculation that I don't feel good about answering something like that.
Of course. Thank you for highlighting that. So Hazel Hex says, does NH think RH planned this by basically baiting the SEC?
No, I mean, that would be, I mean, I'm not sure that benefited him in any way.
I don't think it would, with the amount of money that he's spending. I don't think it
would. I think he tried to make his points over the years that, and I think he's done a good job on many, many streams talking about why it shouldn't qualify under Howey, why his product shouldn't qualify under Howey, why, he's been very clear about, expectations. He's been very clear about common pool. He's been very clear about everything. And, my personal opinion is, if the government tells you these are the parameters, of a law, and let's say they, how far you want to go back? You want to go back to 1600s? Let's go back to the 1700s. I'll give you an example here. Henning's laws from Virginia. Okay, they wanted to raise a wartime tax after the Revolution, and what they did was they passed this law that said they could tax every window in a home that had basically panes of glass.
Oh
so you would pay taxes based on how many panes of glass you had in your house. So, like, let's say I'm an architect back in 1790 in Virginia, and I'm like, well, shit, I don't want to pay taxes on that nonsense. So I'm either going to just, put up shutters, and not have panes of glass in my windows, or I'm just going to put in giant doors that are glass so I can get light in the house, and, in good faith, you follow the law and you design something around what the law said.
Right.
Now, it would be completely unfair for the taxing authority in Virginia at that point to come out to your house and say, yep, those doors are now considered windows, or, we don't give a shit that it doesn't have glass in the shutters. You could put glass in the shutters, so therefore we're going to tax you on all that stuff like that. So this is the problem that I have with the SEC saying, and Howey saying one thing and the SEC going, yeah, but, we think it should cover this as well. What? Mm-hmm. It doesn't. Like, it shouldn't. You should interpret the law as written, not as what you want it to be. So,
of course,
so that's the problem that I have right there. So, anyway, I don't know what the initial question was, but I probably
no, that was good. Thank you. Sparky has a very good question here. He says, "How can the community legally help Richard? No money, obviously.
How can you help him?"
Yeah.
Well, one thing, I mean, if hopefully everybody here has signed off on the amicus brief that was being written, I think, by Barnes. If that was, I think it was Kinetics that put it out or something like that.
Yes, I believe it was Kinetics as well.
Yeah, if you haven't done that, get on that. Doesn't take you any time at all. You don't have to do any work. All you have to do is sign up. I put out something the other day where, if Cynthia Loomis out of Wyoming, senator, and Kirsten Gillibrand in New York. She's liberal, but they're still putting together legislation on who to give authority over crypto digital assets to, whether or not they be classified as commodities or securities, or if there's some kind of definition of a digital asset commodity versus a digital asset security, it will probably come out in legislation like that. So first of all, support that effort. And then the other thing I would do is, given how the Judge Fela in Coinbase the other day thought it was very significant that she had a sitting senator who was drafting legislation regarding the SEC's ability to regulate digital assets. Cynthia Lummis filed an amicus brief in the Coinbase case. I have it linked on my page somewhere a couple days back. You're welcome to read it. It goes right to the court listener, file on it, PDF on it. And then, there's no reason, since that issue existed in Coinbase and also exists in Richard's case, I think it's worth it to ask her to basically file that, very similar type brief arguing the same things in Richard's case. I think that would be very useful, given how, Judge Fela in New York thought it was significant and gave it some weight. So, those type of things I think might help Richard in this case. So go do it.
Cool. Thank you for that. And I do want to ask this question, partial match. It's a question that it's a very, very, very good question. I don't know if you'd be able to, it's not a sensitive question, but I'm just going to ask it.
Sure.
And then,
cool.
if you don't want to comment, go ahead.
Sure.
Does Richard's brief presence in the U.S. doing fresh and fit, et cetera, give any weight to the SEC's case?
No, it's got to be the way the minimum contacts works is it has to be suit-related contacts with the United States. So if he went to New York for a Rangers game, it doesn't mean that you get to say that, oh, you showed up in New York, I can sue him in New York. No. Okay. Unless you actually serve him at that, like if he's present in the jurisdiction and you serve him right there, yeah, you're fucked. But if you're just on vacation and nobody knows that, or you're not doing anything to promote a product or you're not doing business in that area, you're just there for recreational type purposes. No, it doesn't qualify for minimum contacts. I think that the law on that's pretty clear.
Thank you very much, because that was a really good question, and I was hoping you.
It is a good question. Yeah, absolutely.
That was a really good question. So Cyclone Craw. So this is a speculative question. If you want to answer it or not, just tell me if you don't want to answer them. If Herbs had to speculate as what a likely outcome of this case would be, settle for how much, how long does it take? Like, what's your perspective on that?
Again, there's way too many variables for me to even take a wild ass guess at that. So,
okay.
Yeah, that's literally like, what are the 6 lottery numbers coming up? Like, I have no fucking idea. Like, they're going to be 6 out of 58 or whatever the hell it is, right? But I can't guess as to which ones they are. Okay. If I could, I wouldn't be here talking to you.
No, I appreciate it very much, and so does everyone else. There's 250 people in here, so
Jesus.
Yeah.
What are y'all doing? You don't have anything better to do?
And I'm not even counting how many people are on Twitter right now. So a bit Hex says, has anybody ever fought? What was I going to say? Has anybody ever fought for blockchains being freedom of speech? How important will the aspect of freedom of speech be in this case? It's a good question.
It is a good question. I understand that is a pillar of Richard Hart's, philosophy. I do not personally believe it's going to get a lot of traction with the courts. If the courts were, if the SEC wanted to regulate the content of speech online, we would have a different kind of conversation on this. But they're not doing that. They're not saying what you can and can't put up on chain. They're just saying that Richard sold securities, unregistered securities. So I like the argument from a purely philosophical perspective. I don't think it's going to get a lot of traction in real life.
Okay.
I mean, it's as important as freedom of speech is, and as important as it is to all of us, you know, anyone who sacrificed for Pulse, you know, I don't see it as having a legal impact on the judge. Like the judge is not going to change her mind based on that issue.
Okay, cool. Thank you. And Matty Allen has a very good question here as well.
Of course he does.
Yeah, there you go. He keeps the community together with that Hex conference and PulseChain. Got to give him credit where credit is due.
Yep.
Great dude. What happens when no lawyers show up for the defendants of Hex, Pulse, and PulseX?
Probably nothing. Their code, they're not legal entities. You can't really sue them. It's like trying to sue your plant. It's not a, you know, it's property, right? You can't sue code. You can't make code show up. You can't make, you know, it's when you have a legal entity like an LLC or corporation or something like that, they are, well, they're a legal entity. You, Corey, are a legal entity. You know, Amazon is a legal entity. These legal entities can be sued. You can't just sue something that is not a standalone legal entity.
Right.
So I don't see that as a problem one bit. You know, I guess I'm not aware of anything that could make that a problem. So
okay,
it's a good question.
Chris,
I mean, yeah.
It is a very good question. Chris has a question that's not technically a price predictions question. It is a price oriented question. It's a good question, so I'm going to ask it. If you can't answer it, just say it.
Yeah.
Do you think a successful price chart prior to the judge evaluating the arguments bolsters the case in any way?
Huh.
I
don't think it could hurt it. I don't think it will have an impact necessarily because it doesn't go to any of the actual issues in the case. However, like, let's take the absolute most extreme example here, right? You know, it's 3 years from now. Richard's finally going to trial. The SEC is trying to, you know, sue him for fraud, saying one of the statements that he made is ridiculous. You know, that he's going to go up, you know, that it could go up possibly, you know, 14,000x or something like that. Let's say the chart goes up 14,000x. Isn't it hard for the SEC to prove fraud at that point with that statement? Like it does take away, like it's all the wind is out of those sails, right? So I don't really see, I don't really think that the chart is going to have much of an impact. But I don't think it can hurt it. I don't think they can hurt the case or hurt his, because what it does is necessarily it bolsters his statements throughout that you know there's value in this product. It's not you know, crypto is not really seen as anything other than gambling in a lot of circles still. I mean, we're in this community, but you know, nobody really knows. You know, if you're outside of crypto, you don't pay any attention to crypto. So if there's actual value in the system that was created by him, again, it takes a lot of wind out of the fraud claims, doesn't it? I mean, that's just the way I look at it. So
cool. No, and I just want to highlight Brother64. Thank you so much for the $10 super chat. It really does help the channel. So thank you so much for doing that. I very much appreciate it. We're going to go down the questions. And Nuclear, if you have to go at any time, just let me know. I don't want to keep you longer than you have to. So guys, make sure to like, share, and subscribe. But most importantly, in the description of the video, please follow Nuclear Herbs on Twitter. I have his link in the description. I have his handle in the description. He is the one to follow if you really want to, as you can see by the stream. To follow surrounding what exactly is going on. So please follow him. And thank you very much again, brothers, for the $10 super chat. It really does help the channel. You guys, make sure to like and share this video, please. So what's the next question I saw? What kind of weight does an amicus brief hold in a case?
Varying. If it's written by somebody, you know, I guess like amicus briefs are great, but they can be ignored by a judge if the judge doesn't want to consider them.
Right.
If the defendant makes the same argument, the judge can't ignore it, right? It's got to be addressed in some way. An argument in an amicus brief could potentially be ignored. A well-written amicus brief that assists the judge in making a decision on an issue is generally important. And I think that, and it will be given some consideration. Again, like there were amicus briefs filed in Coinbase. One of them had enough of an impact that it was made a decent part of the judge's questioning, the Cynthia Loomis brief. So yeah, I think if you have something that speaks directly to the issue and it's well written and well presented, I think in general, courts will consider those.
Cool.
So
awesome. And you brought up Coinbase. So Duarab says, if Coinbase wins their case, could this change a lot of what the SEC is trying to do with Richard Hart, or are they completely different entities than that case?
The issues are significantly different in the Coinbase case and this one. The only overlapping, excuse me, sorry, man. Still trying to get over that shit.
It's okay. It's okay.
I was having a kind of an online discussion with somebody, and one of the issues in Coinbase it's centralized. Coinbase, one of the issues there was secondary sales. That was a big issue in Coinbase because Coinbase didn't issue any of the alleged securities that they're selling, right? So this is all secondary sales. So I was having a discussion with somebody who's talking about the Coinbase hearing, and my point in that discussion was, we're talking about secondary sales here in a large part, right? The Uniswap is all secondary sales. Uniswap wasn't issued anything by Richard. Uniswap is all secondary sales. And in fact, since you couldn't buy Pulse or PulseX on Uniswap at all, we're talking about secondary sales of Hex only. And that's their hook for jurisdiction in this case, jurisdiction and venue, right? That things took place on Uniswap. And that's the only thing that they've listed so far as a basis for filing this case in Eastern District of New York. So and they don't specify whether or not the one holder that they said in their complaint was a secondary sales or not. They didn't specify. And again, this is court. It's up to them to do their job at this point and write the complaint that that they think they can prove. And if you don't put facts in a complaint, that's then it's you're supposed to get the benefit of any reasonable inferences at a motion to dismiss stage. The plaintiff does, but if there's no inferences to be drawn, it doesn't really help you. So. So I think the Coinbase ruling on secondary sales may have some effect. It's not binding because it's a different court at the same level. But what you could, if you listen to the Coinbase hearing, Judge Fela was very familiar and had read Terra, had read XRP. Like she'd read the rationale of other judges on this and actually asked the attorneys, were those decisions correct? What was your opinion on how that court found, this, that, and the other thing? So I would expect that, if some of these issues are decided in Coinbase, you might get to hear about them in the motion to dismiss hearing. They won't be binding, but I think that, if it's a good rationale by Judge Fela, I think you'll see that, be referenced for sure. So,
thank you for highlighting that. So the next two questions are a bit speculative. So if you can't answer them, just let me know. So Trevor Elliott says, can Nuclear lay out 3 of the most likely results to this case when a decision on the case has been made?
Not yet.
Okay.
Not yet. It's again, too many variables at this point. Ask me again when we get to summary judgment. Okay.
And I'll happily have you on again if you want to, if you're, of course, if you're, comfortable with it as this continues to go on. And Cyclone Craw, how much do you think, again, this is another speculative question, how much do you think RH might end up spending in legal fees?
More than a couple of Ferraris.
From what you
He'd
highlighted before.
have to sell his $3 million in watches.
Yeah.
Yeah, no, it's stupid how much is going to go into this case. I don't even want to know. Like,
yeah, I don't.
The number would make me cry. Like,
Yeah.
it's probably more than I've made in my entire career.
So, Tin Top says, no, I don't know about this, but Tin Top says, wasn't there something about RH being banned from crypto and other financial endeavors in the U.S.?
Yeah, I think that was just fun put out by people. That's just not going to happen. Like,
Okay.
I mean, unless there was some kind of consent order where he agreed not to do something. But I mean, what are you going to do? Stop somebody from talking about crypto? I mean, that's First Amendment stuff. So
Exactly.
You're not getting there. Like that order would be unconstitutional. So at least in my opinion, it would be.
So Astratone says, and again, please let me know if you have to leave.
Sure.
If is Richard's use of sacrifice likely to hold up, though some people cry to the U.S. government? Is there a legalized definition of sacrifice valid, and how likely is it to hold up in court?
Yeah, I have no idea. I like the argument that Richard made in favor of the sacrifice. I like his philosophy on it. It was designed entirely to build a house with no windows that could be taxed, right? Let's go back to that. So, and you should be able to build a house with no windows and know that at some point they're not going to be taxed because you built the house in accordance with the law. This is what the law said the parameters were. These are the lines on the road. I'm not driving outside the lines of the road. Therefore I should, you shouldn't be able to cite me for doing something that I was in compliance with, or at least I reasonably believed I was in compliance with. I guess this goes right to my, the point I made a little bit ago, I guess not here, but on my page was, if hundreds of lawyers, judges, and Congress people can't figure out what the fuck the SEC is talking about, like how he actually means, and how you can design something. Like, how the fuck is somebody going to explain that to a client when they come in and say, hey, listen, I want to design a digital asset that's not going to be considered by, a security by the SEC. How do I do it? And the attorney's just like, fuck, I don't know. Like, I mean, how does that help anybody? Right? You have to have some clarity in this space. You have to know going out whether or not it's going to be considered an investment contract or not, And right now the SEC is saying, in the Coinbase hearing, it's ridiculous. They're like, you're buying into the ecosystem, therefore it's an investment contract. What a pile of shit. Like, it's just a dumb fucking argument. But, I don't get to make that call. So, but that's I don't know. It's, I think Richard did his best, absolute best, to design something in accordance with the law as it was. And I don't think that you should be punished for designing something that complied with the letter of the law, because the SEC is like, well, that's not the spirit of the law. Well, you know what? Put it in fucking writing. If you want it more clarified, then put out a rule. Do your fucking job, SEC, right? Like, I don't know. That's my opinion. I get a little worked up on that one. Sorry.
No, trust me, man. I get it. I mean, when I see different companies leave, I got into crypto in 2017, and I was able to use so many different exchanges that we are not able to use anymore in 2024. And I'm seeing these companies go to the United States as adversaries, or even countries that are neutral or allies with the United States, and you're just taking away a massively blossoming industry. And of course, it has its faults, but with this lack of regulatory clarity that I'm seeing, you're seeing a lot of companies leave, and it's unfortunate. So
imagine you go back to like 1920 right now, and the government basically says, we don't like air travel, so we're going to shut it down. We're not going to allow anybody to, create, airplanes for passenger travel.
Right.
Now that
would be wild.
Right?
Yeah.
I mean, it's insane. You're just watching an entire industry get developed by another country or another series of countries, and you're out. Like, I mean, imagine we shut down the internet, like because it's only used to transmit, messages between bad people. Shut up.
Yep.
Like,
Exactly. No, I agree with you 100,000%. So Chris Baker says, if the SEC does lose, can they continually remain a pain and refile?
If they lose, like on the
Yes.
merits, no. If they lose on the
No.
merits, no.
Cool.
So if they lost a motion to dismiss without prejudice, yes, they could refile. But if they lost on the merits, no.
Okay. And Paul has a really good question here. Do decentralized DAOs count as a legal entity in the court's eye?
I can't see how. Largely because they're decentralized. I don't see how. I mean, I guess, that's another interesting philosophical question. But I don't see a way that could be considered a legal entity. But I don't know. It's a good question.
Cool. So we're going to do, how many more questions do you want to do? I just want to make sure you're comfortable. And this is not like,
I mean, you know what? Everybody's been cool. So, I'm fine with it for a little bit. If you've got
no, I got nowhere to be. All right, I want to make sure you're comfortable. That's the whole main goal here.
I appreciate that.
Yeah, no problem, dude. So BK Handan says, question two for NH. Any possibility of a hidden criminal case behind the civil case?
Is there a possibility? Yeah, there's always a possibility. Would they have done it by now? Probably.
Okay.
Yeah, and here's why. Like, typically, there are speedy trial rules in criminal cases, right? So you're going to get through the criminal case first. Period. It's going to happen. Like, if there's a criminal case alongside a civil case, that criminal case is going to be resolved much faster than a civil case.
Figured as much.
And if you are convicted of some crime that's related to the civil case, it's really hard to go into the civil court and say, nope, that wasn't me. Because the burden of proof is so high in criminal cases, right? And it's so essentially, just mid-range in civil cases. So if you've established the facts that you need to in a criminal case, you have almost no chance of winning a civil case on that same issue. So, if you coulda, you woulda, I think, in this case. So,
okay. So I'm going to amalgamate two questions because they basically can be put together. PulseX Jim says, please clear up that there is no criminal charges. It's just money damage, no jail. And then PulseSock says, the question of hour that needed asked, please explain the consequences from the DOJ versus those from the SEC. Many outside the United States do not understand this.
Okay, sure. What was the first one again?
So basically, he's saying, please clear up that there is no criminal charges. It's just money.
Okay, correct. Correct. At this point, there are no criminal charges brought. Only the DOJ is going to bring criminal charges against somebody.
Okay.
So the minute you see DOJ versus, you're in deep shape. So, but unless you see that, the SEC doesn't have any authority to put anybody in jail. Only the DOJ does. So, SEC stuff is all civil. So as of right now, as things stand today, as we're talking, there are no criminal charges pending against Richard that we know of. I mean, I guess there's always the possibility of some kind of sealed indictment that nobody knows. Again, I think at this point, if you coulda, you woulda. I think, proving criminal charges on this, I guess, would have to be related to fraud, since the issuance of the IPO is not going to be a criminal thing. Mm-hmm. No matter what. I mean, I don't believe that there is a statute that would criminalize the issuance of an IPO beyond, take it out of the SEC's realm. So it would have to be related to the fraud claim. I don't, there's not even enough in the current fraud claim to withstand, in my opinion, a 9B motion, or a 12B motion discussing Rule 9B, which has to do with pleading fraud correctly. And that's mentioned in Richard's letter as well. Like, you have to plead fraud differently than you plead other claims. You have to, okay. Yeah, there are specific rules associated with pleading fraud. You have to state the specific statement that was fraudulent. You have to show scienter, or you have to allege scienter, which is I knew it was fraudulent when I said it type thing. You have to there's a couple other things that there's a couple other elements that you have to basically lay out. And there's been other cases on this issue that just basically realleging paragraphs 1 through 311 doesn't specify enough. It doesn't provide enough specificity to let a defendant know what supposedly fraudulent statements have to be defended. So again, right now, I think the SEC is going to probably, I think that's a really good argument on Richard's lawyer's behalf. I think that they haven't pled it properly. The remedy would, of course, to that would be that the SEC gets to go back and try again. But I don't think that there's enough to establish any kind of criminal fraud claim at this point. And it makes me wonder though, what if Pulse hadn't launched? Would they have an argument at that point? I mean,
good point.
But Pulse, he said I'm going to make Pulse, and took a bunch of money to do it, or at least somebody took a bunch of money to do it. I don't know. I don't have any fucking idea who owns a SAC address, but there was a bunch of money sent to create that product, or sacrifice in favor of that product, however you want to say it. I'm not being super articulate here, but if it hadn't launched, I think there might have been some kind of argument that the statements were fraudulent. I don't think that once it launched, you can really say, he said he was going to deliver this and he delivered this, so therefore it's fraudulent. No, I don't think you get there from there, right? So,
of course. So I just want to give Sparky a thank you so much for the $10 super chat. Thank you for the great stream, guys. Thank you so much. It really does help the channel. So really, thank you so much for that. That really means a lot. And guys, make sure to follow Nuclear Herbs on Twitter as well. Again, Sparky, thank you so much for that. That was very kind of you. Let's see what else we got here. Everyone keeps saying the stream is making the prices go up. I don't know about that, guys. I don't know about that.
Okay, first of all, I don't give out financial advice either.
Yeah, we're not giving financial advice, guys. I don't know about that.
I have no idea. Look, listen, I'm happy if it's happening, but that's nothing. I don't think it has anything to do with this.
No, it has nothing to do with us. Not at all. We're not giving financial advice. We're just trying to clear the air here. There was another question here that I saw that was actually a really good question. Where the hell is it?
Sure. Give me 3 more and then we'll call it a day.
What's up?
Give me 3 more and we'll call it a day.
Cool. Where the hell is it? There was a really good stream here. There was a really good question here that I lost going. Hold on one second. Let's go back up.
No hurry.
We did that one. We did that one. We did that one. We did that one. Let me just see, guys. Sorry, there's so many questions here, and some of them we've already done, so I'm not gonna.
Yeah, there's been a bunch of good stuff, flying by. So,
Lester says, "What happens with the case if Richard shows the alleged items purchased were with his personal funds and not SAC money?"
Well, I guess that would take the wind out of the fraud claim, right?
It's true.
So, I mean, he's allowed to spend money on whatever the hell he wants to with his own money. I mean, the SEC's got to prove that, whatever they said, if that fact doesn't exist and they can't prove it, well, then you lose part of your ability to win that claim. So.
Absolutely. And Maddie, thank you very much for the kind words, and all of you guys, thank you so much for the kind words. I'm seeing all you guys, saying, some really nice things. So thank you so much. It was very kind of you guys. We're going to do 2 more questions. I'm just looking for, some good questions that I maybe have missed because there's a lot of chat going on. Paul says, would you say RH designed and went through the efforts of the Hex contract in good faith with the law and the Howey test?
I think that's pretty clear from what he's discussed on stream. I think it's not like he went into the designs of these things recklessly or in any way in any way ignorant of what the law was. He knew exactly what it was and he did his best to design around it. And, you should be allowed to do that. If something is not illegal, you should be able to do it. So
absolutely.
I think he's, he went back. I mean, I saw some older streams with Richard, like back in, I want to say like 19 or something like that, where he's talking about designing around Howey. for Hex, and it made sense. He understood, like he knows, he made very educated decisions on this, and again, it's the SEC's regulation by enforcement. That's, well, we don't agree with that, so we're just gonna, sue you. Okay, well, I guess this is where we are. This is why we need clarity in the space from Congress. We need it, yesterday.
Absolutely. And Iron Freedom says, how good is the SEC in general in these types of cases? Do they have a win rate specifically?
Don't know. Haven't been paying enough attention. Like I said, I only got into crypto in 21. So, and it really, I wasn't even following Ripple at that point because I just didn't care. I didn't own it, so I didn't care. What woke me up was this case. Like, I was sitting there napping, I got stuff staked for years, and I'm like, I don't give a shit what happens right now. And all of a sudden, like, the SEC shows up and is like, coming after Richard, and I'm like, wait a minute, like, what are you even doing? That doesn't even make sense. So now I'm interested. So now I'm going to be paying attention to a lot of this stuff. No chance I would have listened to the Coinbase hearing without it, without Richard having been sued by the SEC. So
absolutely.
I just got pissed off.
So, I'm first and foremost, I want to say to everybody, there's 250 people in here. I really hope that you guys follow Nuclear Herbs on Twitter. I have his link in the description. Please follow him. I have his handle in the description. Guys, make sure to like and share this video. And I appreciate everyone who donated to the channel through super chats. It really does help the channel.
Yeah, very cool of you guys.
Yeah, thank you very much for doing that. And I see there's 256 people in here, guys. I'm very grateful that this helped. Yeah, there's a lot of people, and this is not even counting Twitter. Nuclear Herbs, is there anything that you want to say before we conclude?
No, I just like to, I'd like to say that I'm a big, I love this community. This has been a lot of fun being a part of it. I'm glad to be here and answer questions for people as best I can. The response that I've gotten has been more than I could have ever expected. I just wanted to calm people down when I started doing stuff, like trying to explain stuff, just so people weren't like running around with their hair on fire. But
thank you.
It's been remarkable, like the love I've gotten out of there. So, man, did I pick the right place, huh?
Yeah,
did I picked the right community.
Right.
Holy shit, yeah.
No, it's a great community, man. I gotta say, man, I wouldn't be here talking to you, or I wouldn't have a channel if it wasn't for this community. And that's very, very true. There's no question about that. It's a fantastic community. They really is. They show up. The engagement that we get is comparable to those with hundreds of thousands of people with hundreds of thousands of followers. So it's the engagement that the Hex PulseChain community know how to show up. This is a fact. So for everyone in here, I really do thank you all for taking the time out to listen to this. I really hope that this was the main goal of this, was to clear the air on things. Nuclear Herbs, thank you so much for all of the information that you've conveyed in this hour and a half. I'm very grateful for you. And as the case continues to create more updates, if you ever want to come on the channel again, my door is always open to you. Thank you so much for what you do for this community, and God bless you, brother.
Thank you, Corey, too. I really appreciate all your support and all your work. And it's been great. Thank you very much.